The court calls the matter of Hovda versus Deneau, case number 2021-5285 DM. All parties and attorneys can please state their name and appearance for the record, starting with the plaintiff's attorney, Ms. Deneau.
Thank you. Good afternoon. I'm Rosie Deneau here with the plaintiff, Jacob Hovda, who's also present via Zoom.
And Mr. Hovda is here. Mr. Hovda, can you hear us?
Yes, I can.
Okay, good afternoon, everyone. Today's date and time set for a motion. This matter is being conducted by remote technology due to decisions of the Supreme Court and Chief Judge. The contents of this video may be the official record of a proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, alteration of said content is strictly prohibited. I'll swear in Mr. Hovda. I'm sure the attorney will make an offer of proof, then may ask you a few questions. Sir, if you'll raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name, spelling your first and last name for the record.
Jacob Thomas Hovda. J-C-O-B-H-O-V-D-A.
Okay. Ms. Deneau, you're asking us to waive the legislated mandate of a 180-day waiting period. Now, what is that? You've mentioned the reasons in your motion, but anything you want to place on the record?
No, Your Honor, I would like to stand on my motion, and based on the fact that the parties quickly wanted to do this amicably, they want to move on with their lives. They believe it's in the best interest of their children in order to allow these parties to move on, both financially as well as their parenting time schedules and work with that. I will tell you that the parties filed in February and signed a marriage settlement agreement within a month of that. These parties have continued to work together regarding the same. And I would just ask that this court grant the motion to waive, as well as allow to proceed with a pro-con at this time.
Mr. Hovda, is everything your attorney said the truth or pretty accurate?
Yes. Yes, it's all true.
Anything else you want to add?
No. Thank you.
Well, I can tell you 15 months ago, I would not have granted this, but learning a few things and through the pandemic and what people go through during a divorce, from what everything in the filing and from what you've stated or agreed with your attorney today, I will grant this. It's upsetting, I imagine, anytime a divorce occurs, but it sounds like from day one, you two put your child first and have come to a resolution on all issues beforehand. I will point out there was a stipulation to take proofs filed, it was dated March 9th, 2021. And in that, the defendant stated or signed the stipulation to take proofs that said, plaintiff may take proofs without further notice to the defendant and in the absence of defendant at any time and in the convenience of the court and of plaintiff and his attorney upon rendition of a judgment of divorce. I do have before me a judgment of divorce that has been signed by both of the parties and Ms. Deneau, and it's approved by the prosecutor's office and the friend of the court. So I will first of all grant the order to waive the 180-day statutory period. I do think it's in the best interest of the parties and most importantly of the child for the reasons as stated on the record. So with that being signed and the stipulation to take proofs, sir, I'll remind you, you are still under oath and I have the judgment of divorce in front of me with stipulation to take proofs. Ms. Deneau, you may inquire.
Your Honor, and I also just want so the court knows a notice of pro-con was served out on May 10th of this year. It may have not caught up onto your file. So the defendant in this matter does have notice as to the pro-con taking place today.
I do see that. So thank you very much. That makes it even more solid record. So thank you.
No problem. I'm sorry. Am I ready to proceed with my questions?
That's up to you. You've already corrected the court once. Anything else you want to correct me on?
How much time do you have?
Wow. I think your client would like to get this done without you being held in contempt. So why don't you ask the question, sir? You are still under oath.
Thank you. Jacob, is it
true
that
just for the record, we are not making light. Divorce is serious. We know that, but this building is so much terrible stuff. I'm glad when a couple realizes they need a divorce and they're putting their child first. So don't take that the wrong way, please.
Not at all. Thank you.
Jacob, is it true on December 29th of 2017, you married Karma?
Yes.
And is it correct that you've been a resident of the state of Michigan for 180 days in the county of Kalamazoo for 10 before you filed your complaint for divorce?
Yes.
And is it correct that during the marriage, one child was born, and that's Willow Grace Elaine, who was born April 6th of 2019?
Yes.
And is it correct that, to your knowledge, Karma is currently not pregnant?
Yes.
Is it correct that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
And is it true that the reason for the breakdown is that you two do not love each other as you did at the time you were married?
Yes.
Now, if this court were to deny your request of divorce, would you go back living together as husband and wife?
I'm sorry, it kind of broke up when you said that.
I said, if this court were to deny your request, would you two go back living together as husband and wife?
No.
If this court has a judgment in front of them and you're asking them to sign it and grant you a divorce?
Yes.
Do you believe the custody provisions in that judgment are in the best interest of Willow?
I do.
Do you believe that the property division has been fair and equitable?
Yes.
All right, I have no further questions, Your Honor.
Sir, is there anything else you want the court to be made aware of?
No, Your Honor.
Okay. Based on the testimony, the court finds there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood the marriage can be preserved. I've briefly gone through the judgment of divorce and the support order. I have signed them, making it official. We will get those out to your attorney and Karma's last address with the court, making it should be out hopefully by tomorrow. Okay.
Thank you.
All right. Best of luck to you and your daughter. Thank you, Ms. Pazin.